The topic of the deaconesses is actually something that's been in the kind of in the circles of the church for the last maybe I'd say 4 or 5 years. About 4 or 5 years ago, Pope Francis had commissioned a group to study the question of deaconesses in the church. However, twice already a study has been done before this. In the 70s, I believe it was under John Paul II was the first study that was done to determine the historical or what do we know about the phenomenon of deaconesses. And in the 70s, the context was a lot of kind of the movements for equality and even for the push for the female ordination, which, for example, in the Church of England, in the Anglican Church, was approved. Well, that was making its way also into the Catholic Church. And so the question of deaconesses naturally came up, since that's the first grade or the first step of ordination. Later on, again, I believe it was in the 80s or in the 90s, there was a second commission that was done, and to study this question one more time again in kind of more recent light. And that commission came with the same conclusion that the first one did, that while there existed this thing called, or what we call deaconesses, they weren't sacramental. They weren't equivalent to what we will call a deacon today, the way we understand the deacon today. Nevertheless, a commission was called again in recent times to study this question, and kind of the commission came to the same inconclusive results. And the commission really said we can't really know too much about what they were because the sources aren't very descriptive. They don't say much. And so again, we know that such a thing, such a cargo, such a responsibility did exist called deaconesses, but we don't know much about it other than they existed and some of the things that they did. So for example, in some of the ancient texts for liturgy, we hear about deaconesses at baptisms, but they were meant to cover the woman who was being baptized, because at the time of adult baptism, you did that naked. And so the bishop would not be in a pool, and remember, this was complete immersion, wouldn't be in a pool with a naked woman. You had the deaconess help and cover and kind of assist at baptism. And then other roots of deaconesses would be found as well in works of charity and works of mercy as well. We hear them mentioned, but again, it's very vague and seems to be very spotty. We know that they weren't everywhere either. It wasn't something that was found throughout the church. Only in certain parts you hear about deaconesses, and in other parts you never hear anything about it. So it wasn't a universal charge either. Nevertheless, a fourth commission was now asked to reconvene and consider the question one more time. And so, since nobody asked me, I'm going to offer my personal study of this. It comes actually through my my doctoral dissertation research. It was accidental. So what I did in my doctoral dissertation, I looked at the laws that pertain to the church in the time of Constantine and what that could tell us about the clergy of the time. And then, interesting enough, I found a couple of laws that mentioned deaconesses around the time I was studying. And so while at the end they didn't factor into what I was in, I was talking about the clerical status and privileges and tax loopholes for the clergy, it didn't quite go in because they were the wrong century. We were talking about the basically the 400s and the end of the 300s, and I was talking about the beginning of the 300s. So it got left out, but I actually did the research. I just never put it together. And so what I'm going to offer tonight is kind of my study, and what came out of that. It was kind of what we call an excursus. I'm going out of sequence into what I was studying, and I found something interesting, but I left it at that. So this is perhaps some future article. So where do we get our information about deaconesses? And so I mentioned that there were different ones. There are liturgical manuals. So for example, the tradition of Hippolytus that tells us how to do baptism in certain times, and how to the preaching or the mass was done at certain times. But it was very, it was actually very. Mira, diles que bajen la voz porque.
Hey guys, keep it down.
Here. And so the sources are varied on different things. And so the sources I'm going to use are particularly legal sources, only law, secular law, not church law. And so the interesting thing is that we find this in the context of secular law. It's mentioned a couple of times. Actually, it's mentioned 4 times, and I'm going to put out the 4 at once. The first, I'm sorry, 3 times. The first one that we're going to look at is from the Codex Theodosianus. The Codex Theodosianus was actually a compilation of law that went from the time of Constantine, right at the beginning of the 300s, all the way to Theodosius II in the 400s. And so every emperor that kind of wanted to leave his mark created a law code, and it was a recompilation of every law that came before him. Interesting thing is that they start with Constantine, the first Christian emperor. And so that first Christian emperor, we have the Romans pretty much considered that their laws begin at that time. In a certain way, we got new law, a law that's based off of that's based off of Christianity. The second thing we find it is the Novella Marciani, and so this is another compilation of laws by one of the emperors, Marcian, and he was kind of this philosopher emperor. He was actually known for his philosophy. And so he re-examined and did a kind of what we call a judicial review of some of the laws that were done by his predecessors as well. Book 5 is interesting. This is where we're going to find one of the mentions, and this is the later mention, so it's not in chronological order. Book 5 is dedicated to estate law. So laws talking about inheritances, laws talking about wills, testaments. It's in that context. It's interesting. It doesn't have anything to do with ecclesial or church or anything like that. Book 16, however, of that same law code is a book that deals specifically with Christian clergy. And so here we find 2 mentions of the deaconesses in book 16. That's telling us that at least in the legal mind and jurisprudence, these deaconesses were lumped together with the clergy. Now we're going to see that clergy doesn't necessarily mean what we think of it today. Today we think of clergy, oh yeah, the bishop, the priest, and back then it was much more wide. It didn't mean you were ordained, but it did mean you were at the service of the church. So we'll see that in a second. And like I said, the Novella Marciani was just a judicial review, which is interesting because the emperor takes a certain case and he reviews a case and kind of reinstates law based on his review of a prior case that was even before his own time. And so he's talking about some case of something that happened way before his time, and he's giving a legal commentary on it. And so we'll look at that one as well. So the first mention is found in the year 390, and I put the date specific for specific is interesting. We'll see in a second why. But June 21st of 390, this law was emitted. Codex Theodosianus 16.2.27. So it's in the section dealing with the clergy, with the ecclesiastics. In other words, that's what we call the clergy, bishops, and clerics. And so that's a very specific thing in there. The episcopis, ecclesiis, et clericis. And well, you have most of the text there. It's too long for me to put over here. But we see that it says, according to the precept of the apostle, and you can look at 1 Timothy 5:9, that's the biblical reference in here. No woman shall be transferred to the society of deaconesses. Now I left the Latin word, the original text in there, because the word they use to describe what we call society, they say consortium, which is kind of the same thing we say in English. A consortium is a society, a grouping together, an association, in other words. And so they say the Consortium Diaconasarum, or the Society of Deaconesses. Nobody shall be transferred to this society unless she is 60 years old of age and has her, and this is a difficult one to translate, votiva proles, la prole, children, we can say offspring. Votiva is where we get the word vow from. Your vowed children? What exactly does that mean? One way of translating is her consecrated children. What are consecrated children? Now, and that they have these at home. One way of looking at this And one translation that I've seen in here and said that her promised offspring, but that doesn't make much sense. What are promised offspring? We're talking about someone who's 60 years old. How old can the kids be when you're 60? Not children that are to be staying at home. And in Roman times, 60, you were at the end of the line. You were ancient by then. So we're not talking about a woman who's still giving birth. The way I looked at votiva proles, in the context of vow or promise, or votiva, your votive children, a woman who's in charge of various children and is promised to take care of them, I think we're talking about an orphanage, orphans. And this woman is taking care of these children that become like hers, and she's got an obligation or a promise to them. That's my read. And so she has these consecrated children of her. If she's 60 years old and has these consecrated, after she has sought a curator for those children, if they require it, she shall entrust her goods to a suitable persons to be managed diligently. She's got to give kind of funding for this orphanage. To be managed diligently and conscientiously, she herself shall receive only the income from her landed estates. Landed estates. We're not talking about la viejita ahí pobre al lado. No. She's got landed estates, and she's got property that she can bequeath or give to maintain a bunch of children that are not hers. So we're not talking about just any woman here. No una viejita. We're talking about, yeah, like you said, una señora un poco aplantada, un poco pudiente, un modo de ser, yeah.
Would that be a widow then, or?
It looks like we're there, because if she's 60, the husband is probably ancient too, or was. Yes.
So along that same line, women could own property?
That's one of the things that separated Roman women from Greek women, or most women from in the rest of the ancient society. Greek women could not inherit property. They could not have property. They weren't legally recognized. Jewish women, same thing, and most of the other. Roman women could inherit property and had property. Eran matronas, what we call them, una matrona. Here we have evidence of una matrona. And so that was one interesting thing from antiquity. So we're not talking about any woman in here. We're talking about a Roman citizen. And so we're not, again, now se está perfilando a little bit the profile of who this is.
This is secular law.
This is secular law. This has nothing to do. This was probably a pagan who wrote it in here. And so it says, she herself shall receive only income from her landed estates, which she shall have full power to keep, alienate, give, sell, or bequeath. She owns it. She could do whatever she wants with it, as long as she lives or pretty much on her deathbed. And the interesting thing, look what the law says here. She shall expend none of her ornaments, gold, silver, embellishments of a wealthy home, her wealth, under the pretext of religion. Seems to be kind of anti-religious, this law. I can give it to whoever I want, but nothing under the pretext of religion. And they clarify at the end of the law, she shall transfer in writing all her property intact to her children or next to kin or to any persons whatsoever. However, when she dies, she shall designate no church, no cleric, or no poor person to inherit. Yeah, it doesn't sound a very Christian law. Now, the context of this law is interesting because in Roman society, it was illegal not to have a will. And I think it's penalized still in civil law. The state encourages you to have a will. If not, you got to go to probate. The state's going to take it. And so the same thing happened with the Romans. That's probably where we got it from. In Roman law, there were penalties for not having a will. And so it implied, number one, that you had some property to give. You needed to leave it to someone. And it encouraged you, well, to have children. And actually, those who were celibate in Roman society were penalized with higher taxes and confiscation of property upon death if they had no children. So this was an Augustan reform, that Augustus wanted to increase the population of Rome. So this is the way it kind of just stayed in the books all the time. So here we see, it's interesting that we have the case of women who probably don't have children, who probably don't have anyone to will, or they want to will it to someone other than their next of kin. And the law here is saying, no, you've got to follow through with whatever it says in here. That was in June 21st of 390. Look what happens, and we'll just take a look at the implications of what this meant. The author of this rescript, now there were three emperors at the time. And this was sent in Milan, so northern Italy. The Augustus and the emperors had split into three. Each one was charged of a different section. Emperor Valentinian II was the one who authored that one. Valentinian II was an Arian. And if we know anything about Arian, that means he was against the Council of Nicaea. Kind of what we say, he's not technically Catholic in a certain way, but he was an Arian Christian. And he was an enemy of St. Ambrose, who was his bishop. Part of that animosity was that St. Ambrose, well, one of the churches of Milan, they wanted to give it to the Arian bishop. And Ambrose said, not in my diocese. And he got some soldiers and blocked the entrance. The emperor got his soldiers and took over the church forcefully and basically got into a scuffle with Ambrose. They didn't like each other. Maybe this was a reprisal against Catholics in Milan. Maybe there were several wealthy matrons in Milan that were donating or bequeathing what they had to the church, and this is his way of sticking it to Ambrose, the bishop of the church. That's a theory. I got to look further into that. But what it does tell us, though, is that deaconesses had to will that wealth according to that law, but they could live off of the land holdings. And so there was an element of a prescribed poverty in a certain way to those who are to be inscribed. And notice the word, not ordained, inscribed, enrolled into the society of deacons or deaconesses. There was a certain kind of poverty attached to it, and a kind of alienating certain wealth, but other wealth they could maintain, which were the landed estates. Yes, you can live off of that. By landed estate, they meant basically farmland that was producing something. But guess what? Land holdings that produce something, they're taxable. And so the tax man definitely was not going to lose his income with these deaconesses, and despite the piety or the devotion or anything. It seems to me that another way of understanding why this law might have been so kind of anti-Christian in sentiment was that the empire wanted to avoid losing very taxable good land around a very wealthy part of the empire at that moment to the church. And this is exactly where it's going to be siphoned off right away by the church. If the widow was allowed, or the deacons were allowed to bequeath or give this land to the church upon her death, that becomes automatically tax exempt. There are a bunch of other laws that I would have to have more time to look into. But essentially, church already was tax exempt at that time. So in a way to protect this law and keep it within the tax roll and keep it functioning, well, again, stop them from giving the lands, because the widows could obviously inherit from their husbands. And apparently they did. Now, this alienates deaconesses from the clergy. Even though it's in the section of clerics, look at what happens, because the ability or the right to bequeath your wealth to the church was something that was given to clerics, priests, monks, bishops. And so it seems that they were separating these women from the rights and privileges of the clergy as it applied to the clergy in terms of inheritance. Now, the second law that's right after it, here's why I put the date, August 23rd. The first one was, you said June 21st, and this one is August here, 23rd. How long is that? Like 2 months. 2 months later, the same emperor rescinds a law. A law recently promulgated, these are his words, with reference to deaconesses and widows, to the effect that no cleric should inherit slaves, household wealth, and landed estates, not even under the name of the church, and that in the absence of kinsmen, basically, if you don't have any inheritance or if you have no children, by marriage, that's the Augustan law, or by blood, he should not conduct himself as an heir of the living under the pretext of Catholic discipline. What are they saying? Apparently some people who are not by marriage or by blood claiming to be part of the family of the deaconess. Whatever it is, that law has now been repealed 2 months later, to the extent that it shall be removed from all records. If it has already been registered, the law shall not be executed by any judge or anyone who brings a suit and tries to claim that law. It's null and void. Interesting. Why the reversal so quickly in 2 months of this law?
It was heavily lobbied.
Probably. One possibility was that the emperor who put it was about to die. And so he dies in 392, shortly after this whole scuffle goes. He also does resolve his problem with the bishop. So maybe the problem was resolved by here. But what it tells us, though, and it's interesting, this restatement, even though the summary kind of tells us how it was being applied in 2 months. And this is what it reveals. Catholic clergy apparently were claiming kinship with the deaconesses on the basis of religion. In other words, yo soy el hijo espiritual de la madre fulana. Oh, we say it still. Yo soy el hijo de tal y tal, even though, yeah, not by blood, not by marriage, but imagine you go to a pagan magistrate and he said, no, she willed this to me. And you're not the husband, you're not the son. I'm her son in Christ. The pagan goes, I don't know what to do with this. He sends it right back to the emperor. What do I do? This guy's saying he's a son of God. Oh, we're brothers and sisters in Christ. Does that count? The law didn't say it, so there you got to revise the law again. And so that tells us it apparently seems to be the argument that has been done in there to get around the prohibition in there. The deaconesses were claimed, this is my spiritual son. These are my sons or my brothers in Christ. Yes, they can inherit, and I'm complying with the law. And so that seems to be one thing that was going on. But what really comes out as a question is, should the deaconesses be even considered clergy? And so apparently now they're being thrown back into the clergy, or they're being lumped into the clergy as far as fiscal privileges are concerned. And that property or wealth that deaconesses had could actually be considered ecclesial patrimony, because if she can will it to the clergy or to the church, that means it becomes ecclesial patrimony, tax exempt for life. So that means, yes, the church patrimony can increase, and it can increase to the deaconesses. That puts them on a certain category all of a sudden. They're like on the radar, so to say. One more law. And 5.3.1, this is 434, so later, concerning clerics and monks. So once again, we see deaconesses are lumped together with clerics and monks in here. And if you just read the yellow, it kind of summarizes the law. Deaconesses, if they should die without having made a will, and if no parent of either sex or children or persons are connected, either by tie of, by blood or by marriage, basically is what it's saying in here. If they should not survive, the property which has belonged to the deceased shall be incorporated entirely into that of the sacrosanct church, or the monastery to which the deceased had been dedicated. So if I'm a monk, or you're a nun, or you're a deaconess, you have no children, you live celibate, or you willed it all to this institution, or if you had nobody, but you were religious, the church gets it, not the state. Yeah, that seems to be a big sacrifice in part of the Roman Empire in there. And so, accepted though, as you see below, if any property actually was taxable before that, certain that, or if the cleric or the monk or even the deaconess technically was not tax exempt, and there were some clergy that were, even though they were clergy, the tax exemption didn't fall on them because they were too rich, basically, is what happened. Oh, no, they're not covered by this one. No, we're holding on to that estate. And so you can imagine where the lawsuit's going to be. They had probate also basically in the Roman Empire. And so the, let me go back here. Yeah. And so we see that, someone who dies intestate, but was connected to it, well, the church now takes it, and so gives the prerogative, or definitely the advantage, to the church, and it creates an ecclesial patrimony little by little already. What can we take away from this? Number one, deaconesses, clerics, or monks who die without heirs forfeit their property to the church and the monastery. The same way that if we were to die without an heir, or with no will, the state takes our house, takes your whatever, well, the church was given that prerogative for those who were enrolled somehow in the clerical service of it. And again, let's get out of our minds that clergy means you're ordained. Not necessarily. Monks are not ordained. But they are here, at least in secular law, they're considered clergy. They're lumped into that category. The property of deaconesses, clerics, or monks that was subject to taxes can be taken by the municipality. So again, it's telling us that these deaconesses had property. And it wasn't just a little piece of land. Apparently they inherited goods. So it tells us maybe they tended to be senatorial rank. They were widows, rich widows who received whatever from their families or from their husbands. And they were still actually running and benefiting from it. So it wasn't intended to the poor little old lady that wants La Beata that goes to the church every day to pray. No, this seems to be a more precise group. Third thing it tells us is that if deaconess, a cleric, or a monk was not exempt from municipal taxes, well, obviously that may be taken by a municipality. And if a deaconess, cleric, or monk dies in debt, and this is the part that I skipped, it's just too long to put in there, the creditor can sue and take what's owed to them. And the estate of the deceased may be taken to satisfy a debt. So again, we're talking about business people here, businesswomen. They've got debts, they're incurring sort of debt. We're not, again, talking about just your average lady who wanted to serve the church in here. Deaconesses tended to apparently be an upper echelon, wealthy group of Christians at this time. Now, the last time we see in law, again, there are many different mentions of deaconesses in other sources, but I'm just dealing with secular law only. In the Novella Marciani, basically the laws of Marcian, he's talking about the Testamentis Clericorum, on the wills or the last testaments of the clergy. Once again, deaconesses are lumped into the clergy. And it says, and it's a very long thing, so I had to paraphrase it here, but if a widow, a deaconess, or a maiden, a consecrated virgin is what we call her today, a maiden consecrated to God, or a holy woman, or a woman who is called to any other name. By this time, by 455, apparently there were so many different names they gave to women that served the church that he's trying to get them all in here. They're called maidens, they're called deaconesses, they're called widows, whatever they may be. If you're a woman that's consecrated to the church, and you should suppose in your testament a church, a martyr's shrine, a cleric, a monk, or the poor, or anything to these people in the form of property, that is valid. It cannot be taken away. It must be honored. So he's restating the law that was rescinded basically in there, and he's kind of going over this this practice. He concludes saying, if any property should be conferred by gifts or also as an act of generosity by widows as well as deaconesses or maidens who have been consecrated, or by holy women, well, I command that such gifts be valid with equal force, and so that it has to be protected. Why did the emperor go over this? This is kind of interesting. Again, this emperor was a philosopher, he was a jurist, he kind of went over old cases, kind of landmark cases, kind of like what I guess the Supreme Court would do today, and threw his opinion on it. He was the emperor, he could. He was reviewing the case of a certain Hypatia and Father Anatolius. Now we don't know when this is, but apparently this was before his time, because he says, in the revered memory of the late Hypatia and Father Anatolius, so that means probably before him, they died before him in there. Apparently this case was brought up to imperial probate. A certain Hypatia appeared to be a very wealthy woman, had willed not only her estates, plural, but also her wealth, her jewels, her gold, to the bishop, to a monastery, to Father Anatolius, who she said is my spiritual son. Father Anatolius was not her son, it was her spiritual son. And to the poor of her region, because that is the gift of the church, and she was fulfilling her Christian duty, and she just basically gave everything away upon her death. They wanted to take it away from Father Anatolius. No, you're not the son, you're a so apparently this must have happened when the first law went around when did we say? It was 390. It was when the first law happened in there.
First 24 years.
Yeah, so Anatolius was the case. Good thing is that we got the names now. It took a while for them to get it, but we get the names. And so apparently Anatolius sued. It's like, no, I'm the son. And it says in her will that I'm her son, I'm a spiritual son. And apparently the court did not want to give him. But with the rescinding of the law, basically months later he came back and goes, gimme. And they had to. So he's going back and he's reviewing pretty much the proceedings and says, I agree with the way the judge handled that he gave this law according to the rescind. And from here on, I also declare any case similar to this, automatically give it to the church, to the benefit of the church. What happens is, what is the outcome of this? And this is in the mind of the legislator here. He's now recognizing kinship on basis of religion. I can now claim that I have spiritual sons even though I have no sons. I can have spiritual sisters and brothers. And they can legally be my heirs of church property. And if they themselves are clergy or monks or nuns, what we call, or deaconesses themselves, they're tax exempt on top of it. Because it's, pretty much. This looks like what we're getting at. Without calling it, that seems where we're going there. And so, you've seen that Father Anatolius was designated as your spiritual son. The priest can actually be part of the household, and that's a legal term in Roman law. To be part of the household is literally to be part of the family. Slaves were part of the household, and therefore they were treated and considered family, even though they were slaves. And they could be bought or sold, but if you were part of the household, enrolled in the household, you were considered family. And certain law applied to you as being a family member. So that means now hereditary law can be applied to someone who's not bound to you by blood or marriage. It can be applied to your household. So now these women are basically creating new households, Christian households, spiritual households. Interesting. Again, we're not talking about now just any nun. We're talking about, there's a reason why they call them Madre Superiora.
Oh, that's not mine.
They're forming a home. Now, the interesting thing is that the emperor himself notes that the previous laws tended to equate widows and deaconesses. So that's where we see, it seems that the deaconesses had to be widows already. It seems to be, because that's where they got the property from, that's where the wealth is based, and it seemed to be questions of succession in there as well. So apparently, even the emperor at this time is saying, yeah, deaconesses apparently were widows. So that seems to be a prerequisite. And any woman can designate the church and clergy as her legal heir. And so that kind of brings women, it brings this class of women, whereas the first law kind of segregated them from other women, because other women could go ahead and will out their property to whoever they wanted, except the church. Well, now forget these women now are now kind of brought into parity.
Well, just a question about the confirmation of the spiritual relationship. Was there any indication that there was a requirement to demonstrate some relationship? So, for example, a person who had adopted somebody could be a spiritual mother, right? In the case of the orphanages we talked about earlier. Or that had some sort of spiritual congregation, and that priest, came through the congregation. Was there any requirement to demonstrate that there was a relationship?
I suppose there will. And I can imagine in the case of Anatolius, he's like, look, it's right here. It's on her will. He's calling me her son. So, here it is. But yeah. Oh yeah, and this, I wouldn't know. I mean, they did have ways of doing it, though. I mean, they would be some sort of script or something that to make it official as a record. Now, one thing that Marcianus concludes in his kind of lengthy review of this was that, again, he's using all the titles of women. So apparently, all holy women, whether it be widows, consecrated virgins, which are basically nuns for us, and deaconesses, he's lumping them all together. Apparently, it was the same thing, and like this law applied to any of them. It didn't matter which one they were. So it might indicate that, well, what we call a nun today was probably called the widow in some other place, or called a deaconess in another place, or called a consecrated virgin somewhere else. We're talking about the same thing, except they just had different titles wherever they were. But the conclusions were that, number one, deaconesses, apparently, if we go just by secular law, we're not talking about poor women. Yeah, we're talking about wealthy women to begin with. So that's already telling us kind of a stature already. Deaconesses most probably were always widows. That seems to be kind of a prerequisite to this. It's not telling us what they did so much, but who they were. And this is where the value of this law is. Deaconesses apparently seem to do some charitable work. If they're giving away their gold to the poor, or they're giving away this, they're doing charity. All right? More and more, it looks like we're what we call today a nun, a sister. I mean, they're doing charitable work. Not all of them are poor. Well, widows in a sense, they're not married. we're getting there. It's like this is formulating it without calling it so. Even though secular law categorizes deaconesses as clergy, I don't know for convenience sake, but it's there. I mean, the way that the civil law is looking at them is as if they were clergy, church law does not recognize them as such. It kind of fails to use that. And so later on when you see in the councils and all that, they do mention them, but they're not counting them as clergy. So there is a dissonance in there. There seems to be a disparity in there. But it's interesting how secular pagans looked at them. It's like, yeah, they're all clergy. They lumped them together. Deaconesses would now be subject to the same fiscal exemptions as the rest of the clergy. So this is another reason why I would say that secular law considers them clergy, whereas church law doesn't, on the basis that they're held to the same fiscal privileges, which in Roman society, that's how you distinguish classes. We talk about classes today based on wealth. You know, the lower class, middle class, upper class. Not in Roman times. It was a little bit more than that. It was almost like caste. I mean, you were born into it, but you could have poor senators, and you had rich freemen, former slaves, that were richer than some, but they still remained in their social stratum. And so what it seems to be here that the new stratus that was created of this thing called clergy, deaconesses were now inserted into at least the social rank, secular rank. And there's two more things here. Clerical status at the time, again, as I've been saying over, does not imply ordination. And apparently, so because they're mentioning monks, and monks, by definition, are not necessarily ordained. And so they're included in all of this. What's the female of monk? Monho, monha. Well, nun. In English, the word is not related to it. But the last thing, and I think here's the takeaway, is that the order of deaconesses most likely resembles a religious order, what we call today a religious order, but not holy orders. Doesn't necessarily mean that they were ordained. They belong to an order, like I belong to the Jesuit order, but not every member of the Jesuit order is ordained. Brother Mike is not ordained, but he's a Jesuit. You have Jesuit brothers. They're not going to be ordained either, but they're full-fledged Jesuits. And so what we see here, and in other language, they do talk about an order of deaconesses, but in as much as it's a religious order, almost. A proto-religious order, without calling it that. And so that's kind of my 2 cents in this whole debate of it. Again, people today are trying to equate it to what we call the diaconate today, the male diaconate, or the diaconate as we know it. But that's kind of superimposing a modern understanding of the diaconate to something that was anachronistic, that's out of the time. We can't impose our definition today to something back. The same way we can't say clergy today is defined, starting with the diaconate, priest, and episcopacy. Apparently not back then. That wasn't the same thing, even though we're using the same word. Yes?
Wait, real quick. If anybody has a question or comment, there's a microphone on. I have one here, but after this, I have one here. On each table, please utilize that for the folks on YouTube. Go ahead.
I just think that, I mean, this looks to me like a legal definition.
Mm-hmm.
They're taking the word deaconesses out of context.
Mm-hmm.
The word deaconesses was used in Roman law. It wasn't, at least from what you said, it looks like it wasn't used in, quote, let's call it church law, assuming that there was then. So basically, they were using it in a certain context in order to try to tax them, and they were trying to avoid taxes.
Yeah.
But that has nothing to do with what the church was doing.
Right.
But people today are saying, oh, because they used the word deaconesses then, that means that they must have existed. Well, I'm sorry,
Yeah.
but that's like revisionist history.
Exactly.
Looking at what you said in relation to the diaconess being a she, being with a poor lady or something, were the militaries capable of owning property just like any other man?
Mm-hmm.
Because it looks like that this was a little bit addressed to the widows of those military that unfortunately died in the field.
Mm-hmm.
And they were, she ended up with a lot of wealth. She may be not necessarily, inclined or not inclined to a particular religious, but maybe she may have been very, very fond to helping somebody. She was definitely related to the elite in a way or another. So they were kind of, this is a way to protect them so that she could be enjoying some of the wealth her husband created at the same time. So freedom for her to dispose of them as she sees fit.
I think it's interesting, usually the secular law or the secular society won't legislate until there's a significant reason to do so. So to see the Roman law step in and say, wait a minute, we have a significant movement with these women who are, quote unquote, running away with our property and giving it to the church. We got to step in and do something.
We got to put it in context because the first legal or fiscal exemptions that were given to clergy started with Constantine, so they had already been going on for almost 100 years. And so Constantine was very vague when he said, to the church, I give this right. Okay, what do you mean by church? Do you mean the bishops only, or do you mean... And so even lectors and the choir, oh yeah, we're clergy, we're exempt. No, not so fast. So they had to start defining what exactly we mean by church. It takes a long time.
You see that happen today?
Yeah.
People fight over what's the meaning of, lawyers fight about all these nuances all the time.
Now, it's true what Eric said. Roman law was reactive. It was not proactive. So the emperor didn't think, let me think of what we're going to do to avoid having a tax problem in the future. No. When the problem presented itself, they had to figure it out. And so apparently, they saw the problem of probably all these the people claiming inheritances from the deaconesses and saying, oh, well, I'm tax exempt. No, you're not. And then that went south, that they had to rescind the law. And so, yeah. And maybe by the time of Marcianus, it came up again. And he's like, let me study this all over again.
Let me say that I'm not in favor of the deaconesses, and less so after tonight. But there's something that is very important, which I said, not necessarily imply ordination, but what it was so called in the past, the lower orders or whatever, that were the lectors and the acolytes, that now is like something that has to be done for anybody that is studying to be a deacon or to be a priest, and of course it doesn't imply an ordination, but it implies specifically some status and position within the church, because indeed that's how these positions and these studies bring about. And these are not allowed for women, and even though it doesn't imply an ordination, but they do many things. They are a lector, they are a communion minister, sometimes they even help the priest, and I figure that they could be able to apply at least up to that level that doesn't imply an ordination.
I just think the important thing is to separate. I think the important thing is to separate secular or legal isms from church tradition, law, whatever you want to call it.
Indeed.
This is, at least the way you presented it, is altogether different. This has nothing to do with the church. This has to do with Roman law. But that's secular law. That has nothing to do with what was going on in the church. So for somebody to say, okay, if somebody is relying on these mentions to say, oh, this means that we had deaconesses then. Excuse me, they're mixing things in order to carry out their purposes, but they're two separate things. It's two separate tracks.
Right. I mean, we can't deny that there were certain people called deaconesses, apparently, because they're mentioned over and over again. So they did exist. Now, what they do and how they were, Well, yeah, obviously this is not going to tell you, but it gives us an idea of who they were. And I think from that, because again, it's very scarce, and when you look at actual church references that talk about it, they don't say a lot about it. And so this gives us, I think, a profile that definitely church law or church references don't give us.
But is there any mention in Roman law about the word deacon as opposed to deacon?
Deacon shows up in the initial tax exemptions when they were clarifying who gets it. And so they start saying bishop, presbyter, deacon, subdeacon. Or in Africa, it was bishop, presbyter, deacon, subdeacon, lector. They were considered clergy. So the name shows up. What it does tell me, though, is that the legislator is unfamiliar with what these terms mean. So I was like, oh, yeah, whatever the Catholics call or whatever the Christians call it, this is what we're going to give the exemption.
So, Father, a comment and a question. A comment relates to some of the historians, some of the studies on history have indicated that the development of Christianity and the Roman laws associated with the development of Christianity may have been one of the things that weakened the strength, particularly the financial strength of the empire. So hearing this, I can see where that may have developed, because this became such a common phenomenon, apparently, that the emperors were actually changing laws within 30 years. So interesting, dynamic, because the church was strengthening at a time that the empire was actually weakening dramatically. However, that may have set the church up for strength in the Dark Ages, right, after the empire collapsed, particularly in the West. The question, given that you indicated that this has been studied a number of times, why does it continue to be studied within the same century? Because the implications of that is that each prior commission got it wrong, right?
I would say what that implies is that someone's not happy with the answer. They're not saying what they want them to say.
By the way, table one is out of time.
Table one's time.
However, I want to pay respects to Benny, because I think he made a very good point twice. He made a good point. So, my question is this: you said very specifically from the beginning that this was going to focus on secular law, but that there were other mentions about deaconesses elsewhere. So can you say anything about that, or?
I need another half hour. You want it?
Next week. That's a follow-up. Eduardo had a comment.
Yeah, well, I'm going to follow up some of the ideas that have already been said. One of the things that I wanted to ask Father is, I can see where some of these studies started, and even John Paul did it, but then I'm trying to reconcile in my mind Ordenatio Sacerdotalis from John Paul II that made it absolutely clear, beyond a shadow of a doubt, that women, and he made the theological arguments as to why, that women could not be ordained to be a priest. Now, if deacons are holy orders, how then can anybody imagine that you can study this to death unless you ignore what John Paul did? I mean, is it that people don't believe that the ordinary magisterium of the church, as because John Paul II was asked why not make this a dogma, and his answer was, this is part of the ordinary magisterium. Are we ignoring the ordinary magisterium?
No, that's what they would want to do, and definitely to reduce the value of tradition, because one of the things that our faith and the magisterium depends is not just on scripture, but also tradition. And I say tradition with a capital T. And so that tradition has been established since time immemorial, and this is one of them. I would add on top of that, on top of, you can say your biblical and your theological reasoning and legal reasoning and whatnot, an anthropological reason. And that the equivalence of what we call a priest, whether it be Catholic or pagan even, but what is the priest but the pontifex? He's the bridge between the divine and humanity. The priest is, by excellence, the one who sacrifices to the divinity. on behalf of her. He's the one selected to do it. Not everybody can do it. There tends to be certain people who are. In every culture, ancient culture, it's always a man. In the Egyptians, it was a man. In the Romans, it was a man. In the Greeks, it was a man. Yes, there were priestesses. They were the wives of the priests, and they carried the title by, we call it by the honor, by honorific. And so you had one of the famous cases are the Flamines. So these were what was called the Flaminian priests, which were the honorary priesthood that the politicians had. Their wives were also priestesses. They did not offer sacrifice. They just stood there with the candle. They were part of the procession, obviously, because they had to be with their husbands. You see this also paralleled in our own society. They say in military bases, the wife of the commander or the captain almost has the same rank as, even though she's not in the military. And even amongst the women, they'll follow the ranks of their husbands. And so, the wife of the general obviously is given a little bit more leeway or more kind of precedence than the wife of the lieutenant. And if one moves up, she moves up, even though she's not a member of the military. The same thing was being applied to the priests, I think, in general. Those priests, pagan priests, their wives were priestesses honorarily. And at this moment, we did have priests, Christian priests, who were married, obviously, although it didn't seem that honor transferred over to the wives. Why? Because this was not a symbolic or just a ritualistic priesthood. There was something there. And I think there's that anthropological reason. The man is chosen. That just as the woman is chosen to give life, and you can complain about, you can wish to get pregnant all you want, but you're not. Well, the man was chosen to offer the sacrifice. That's our burden to bear.
Good. One comment that I would add to what you said is the fact that it doesn't make sense because the priest in the church, when has the unique and sole power to consecrate, this is my body. If a woman says that, she's lying because you're acting.
We're not talking about
persona Christi. So how can that be? That's what I don't understand why people object or think that women can be priests.
When you're in a time of the gender fluidity and all that, then yeah, they're looking at it, it's like, well, you can't say Christ was really man, he means both. But no, we take that quite literally. I mean, I would say, you do see a female priesthood in some other religion, but they seem to be a little bit less developed, like in witchcraft. Yes, obviously the woman is the one who's filling the sacerdotal role, but yeah, in brujeria, and I think in the Norse, in the pagan Norse religion, same thing. The woman would do the sacrifice, but it's by exception, and we kind of, if you want to do the politically incorrect thing of grading or putting the development, not as developed as we'd say some of the other ancient religions were. Diego.
Okay, so a few things. The first thing, thinking what you were saying about the priestesses carrying status by extension, it reminds me of the question of why we listen to anything that any first lady has.
There you go. By excellence, that's it. We didn't elect her, but you listened to her.
So on the previous slide, you have a sentence where it says that the deaconess can have or can claim a priest to be part of that household. Does that imply that it's limited to one, or was there any sort of limit?
No, apparently it would have been multiple. It could be several. And so that thing about the children, that's in the plural. Yeah, her spiritual children tended to be more than one. So again, we're talking about a woman that has the means to sustain many people.
Right. So that's on the giving side. On the receiving side, can one person have more than one household?
Good question. I don't know. I'm inclined to say no, but I can't. I don't really. I can't say it definitively.
Second lady.
Can I belong to two households? I don't think I could. I don't think it's. At least culturally, it wasn't foreseen.
My last question. Were these discoveries novel to yours, or been something that's been...
I'll just say that with what I've read from the commissions and all that, nobody talks about this. They're using the church sources that I mentioned, the tradition of Hippolytus, the apostolic tradition. They're using biblical references, theological. They're not going here.
You know why? Because it doesn't help the narrative.
Ah.
Of course.
So that's why I think I'm onto something. Thank you.